Hello, everyone. Thank you for tuning in today. Welcome to Sign for Moore Injury Funding, the podcast for all who want to learn about legal funding and its significance in the personal injury, rideshare, defective products, medical malpractice, trucking law, workers' compensation, and many other types of law practice domains. I'm your host, Laura, founder and CEO of Moore Inkiry Funding, the legal funding counselors for passion, with passion for law, medicine, legal funding, and heart for all suffering individuals. In today's episode, I have the honor to be talking to attorney Jeremy Pineres with Jeremy Pineres Law based in the heart of Buckhead, Georgia. Let me tell you a little bit about Jeremy. He's originally from Miami, Florida, and graduated in the top 1% from the University of Central Florida and earned his Juris Doctor from Emory University here in Georgia. He has worked with in-house counsel at DHL Express and interned for Judge Lawrence D. King. He's a member of $1 million and multi-million dollar advocates forums. He was named a top 40 under 40 civil plaintiffs attorney in Georgia in 2020. In his free time, Jeremy enjoys fitness, hiking, and supporting animal shelters. And I'm sure I left out a lot of very important things, but that's something for Jeremy to share with you all. So today, what we're going to talk today is we will dive deep into the hidden price tag, why skipping a personal injury lawyer can cost you a lot of money and time and pain. At the end of our episode, I prepared a fun pop-up question for our guests, so stay tuned. Welcome to my show, Jeremy.
Thank you for having me. It's good to be here.
It's so good to have you with us today. Can you tell us what is the mission and values of your law firm?
Yeah, so our firm exists to empower injured victims through education, accessibility, all the things that typically feel very much out of reach when you're at your most vulnerable after what is probably for a lot of people a once in a lifetime event, whether it's a car crash or, slip and fall, med mal, something or another. A lot of times people go through those things a little bit blind and not knowing what happens next. And so we try to bring a level of accessibility, not just to the justice system, but also to what we're thinking as we go through the process.
And let's talk about the initial client contact. Why do you believe that direct client communication with an attorney is essential for any and every case?
Yeah, so there's a lot of good reasons for that. The main thing that I have found is that when someone else is talking with the client for me, there is going to be on some level information loss, whether it is to or from the client. So as much as I can, I try to make sure that all my communications with the clients are direct. We will email, we will text, we will phone call. All that stuff is just to improve not only the experience for the client, but also ultimately the case results.
Let's tackle the legal process step by step. Clear and simple communication while explaining the legal jargon to clients is essential. How do you guide your clients through each phase of your cases?
Yeah, so phase is an interesting word to use there because the system we use is literally categorizes cases based on phases. But as far as like on the client side of things, there's a few phases that we like to think of just off the bat. The first is always the onboarding. That process is where we will talk with the client, give them kind of a 30,000-foot view of what will happen, and then break it down to them into more bite-sized pieces for what we're doing now, what we want to have from the client. They might have information that we need, and then give them a little bit of what the next steps will look like, just kind of based on where we go with the case, how their treatment goes, what communication's looking like back from either the defendant or their insurer. Just giving them a lot of information, but in bite-sized pieces so that they can digest it.
That's very helpful to know. Let's discuss the significance of educating clients about their case. Can you, Jeremy, explain why certain actions are taken and what clients need to do or avoid?
So the number one thing I would say they need to avoid is after a crash, you are definitely going to get a call from their insurance company, that them being the at-fault person. The number one thing to avoid is that conversation and telling them stuff that you don't need to be telling them.
Like what?
Yeah, and I mean, it's funny you mentioned that because I was just reviewing a recorded statement that a now client had given to an insurance company, and it makes me sad. It hurts me on the inside because during those conversations, they will end up saying things that will bite them later on in the case when I'm reviewing the transcript of it. And it's stuff that they don't think is harmful at the time when they say, "Oh, only my shoulder's hurting right now." That's not inherently bad, but it does put in writing a time frame for when this pain started versus another pain. And what they try to do is frame it in a way that, okay, if this pain was not there back then, why is it there now? And what's something else the cause of it? And so a lot of those circumstances we can avoid by just foregoing that recorded statement altogether.
And it's interesting because right after the post accident, immediately couple minutes or moments after that, the injured person may be full of adrenaline rush, and so because of that, because of the anatomy of the injury, they may not feel the pain right away. It may take hours, days,
Exactly.
and so you have to be very
Exactly.
careful about that. Can you, Jeremy, share a couple of examples of common misunderstandings?
A very common misunderstanding is that anything that we obtain against the defendant, at least in that pre-suit, insurance is involved time, even in litigation, when insurance is involved, is that the defendant is quite literally the one that is paying them. There's some level of sympathy and on some level empathy for the person that hit them. And so they don't end up wanting to pursue a claim thinking that, this 16-year-old that hit them or this, single mother that hit them is one that is quite literally paying for their medical bills or paying for their pain and suffering, when that's not the case. I mean, it's going to be an insurance company behind them that they've been paying the premiums for that pays for that.
And when we think of client empowerment, what methods do you employ, methods or, ways do you employ to empower your clients and make them feel involved in the process, which I believe is very, very important. Also, do you have any tips for clients to prepare for meetings and interactions with your law firm?
Yeah. As far as methods, it's not like a super secret method or anything that we use. I like to just consider the accessibility of our attorneys to be the method. If clients have questions on almost every call that I can think of, I will always end it off with, "Hey, I know I've kind of just given you a ton of information. As I'm talking, though, please feel free to interrupt me to ask a question." And then at the very end of the conversation, I'll always ask, "Hey, any comments, questions, concerns you might have right now that we can talk about while we're, just on the phone right now." It ends up that, most times there are no questions. Sometimes there are. And I always encourage my clients to ask another attorney here, for the answer to a certain question I might have, because I'd rather you have too much information or, questions that you want answered and get the answer and know what's going on with your case than to, be wondering, why was something done on my case? Why am I doing this for my case? As far as preparing for meetings, the biggest thing you can do is just be involved in your case. If you're going to the doctors, a chiropractor or an orthopedic doctor, it doesn't hurt to just ask, like, "Hey, how does this help my case?" Because a lot of clients, they'll go to doctors and not know why they need to be regimented with going to every appointment. And just even that question of, "Hey, if I miss an appointment, is that a big deal?" One appointment, no. 5 points in a row, maybe. But explaining why that matters is what makes the client involved in their case too.
And how do you normally communicate with your clients? Zoom calls, text messages?
All the above, whatever is most convenient for them. Some clients love when I call them. Some clients love when I text them instead. A lot of clients, I'll email them to find what time is a good time for them for us to call, talk on the phone. Some clients we've connected over Zoom. A lot of them like to come to the office just to shake hands, kiss babies, and to pet Caroline. But whatever's most convenient for them, we make it work. It's not anything. It's no skin off our back to text versus call, or call versus Zoom call, or have them in the office. Just whatever's easiest for them. Yeah, the number one thing is, as long as they stay in communication, that is all I can ask for.
And it's amazing that you are willing and working, with each client to accommodate their preferred way of communication. There's much at stake if or when an injured person chooses to handle their case on their own. Why would you say hiring a personal injury lawyer is critical?
Yeah, so There's a few reasons. I mean, there's three main ones. I'm just gonna kind of say from the top of mind. The first one is making sure that you're not being shorted on your damages. And what I mean by that is very early on, I've had it be the case that they reach out to, they've reached out past tense to a current client of mine, back before that person was represented, and tried to offer $5,000 for their claim, and they say, hey, we'll cover up to $3,000 of medical bills and we'll pay you $2,000 for your inconvenience in having to go through this crash. And what that really means translated is up to $3,000 of medical expenses and $2,000 for pain and suffering. And, most people, if this is their first crash ever, if this is their first time going through the process at all on their own, they think that might be a good deal, because they don't feel anything right after the crash, like you were referencing before. And so they think, okay, cool, I might need to go to the doctors, I might not, but $5,000 sounds great. And a lot of times that can leave clients with medical bills not paid for, because if you've ever gone to a hospital and you gotten a CT scan, that bad boy is like $4,000 off the bat. But if you've never gotten one, you don't know that price. And so that number from the insurance company looks very attractive at that point. The second reason is more on the foundational level, making sure you don't make those mistakes that we referenced before. It's like, talking to the insurance company and in giving them a recorded statement, capping your own damages because you didn't know the full extent of your damages because it's only been a day or two. And then, lastly, it kind of ties into the foundational stuff. It matters because there's a lot of stuff that we do to make sure that if this case needs to go into litigation and if it needs to go to trial, that there is certain evidence that they have preserved, that they knew to preserve that stuff, so that down the line, if we need to request it, they still have it. And that's, easily probably the number one thing that needs to happen on every case, is telling them, hey, preserve any, cell phone evidence, any vehicle data if we need to pull it early on, or if we need to, tell them, hey, don't do anything to the vehicle so we can go at least take a look at it, take pictures, whatever the case might be. Just making sure that the insurance company knows to not destroy evidence.
Yes, interesting. Do you have cases? Do you have some cases where that happened, where the insurance company destroyed evidence?
So, yes, I don't want to, assign any level of intent to it. Because it's not necessarily the insurance company destroying evidence intentionally. It'll be, at least not in my experience so far, it'll be them not having the client preserve a cell phone that had information on it, and they get a new cell phone. And then by the time that we are in litigation, or if we need that cell phone, it's no longer there, or in another case there, this company had sold off all of the assets, and one of the assets that the company had was the vehicle that was involved in the crash. And so by the time we were on the case, that vehicle was long gone. The data from the vehicle was no longer there. It wasn't even, accessible at that point. Because you're also asking a separate company altogether to kind of cooperate with you too.
Thank you for explaining it so well. Can you explain to us, Jeremy, what your recorded statement is and its significance? In addition, can you please discuss how insurance companies can use these statements against injured parties? And, we kind of started talking about that, but can you elaborate a little bit more?
Yeah. So, I mean, there's two recorded statements. One is with your own insurer, which if it's your own insurer and you're trying to open a claim on your own insurance policy, you have to cooperate in their investigation. But the at-fault insurance will typically reach out after a crash. It's usually within that first week. I've seen it as early as the same day. I've seen it as late as like maybe 2 or 3 days later. But they will try to get you to give a recorded statement on how the crash happened. They're asking details about the crash, but then the part that gets a little dicey is when they start talking about, are you injured? And the way that can come and bite you in the butt later is because, again, at that point, your adrenaline might still be pumping very much through your body and masking a good amount of pain, or there's just certain pains that have not developed yet that we don't want to be telling them do not exist at that point. And so whenever, there is that missed call with a voicemail that says, hey, give us a call back, we just want to get your statement on how this crash happened and what you might be going through, the initial reaction should be no. The only statement that you're going to be getting from my clients at that point is the demand letter that says exactly what you need to know and how you should be evaluating the case.
So what you're saying, if somebody gets in a car accident, do not call insurance company at all?
Not necessarily not to call them at all. If you're handling it on your own, you have to open the claim more than likely. But any sort of documentation or statements about bodily injury, I would recommend getting an attorney, even if it's something very, very, very simple with very, you know, expected minimal injuries or anticipated minimal injuries. You're not feeling too much. I would still try to talk through someone else who is going to at least be that, bodyguard between you and the insurance company who says, don't talk directly to my client, talk to me.
Good to know. Can you describe for us a typical scenarios where justice offers settlements early in the process and explain the risks of accepting low offers before consulting an attorney?
Yeah. So, we kind of touched on this before, but if it's early enough in the process, you can have a case where some adjuster sends an offer that looks very attractive that early on in the process because you don't know the full extent of your damages. There's a couple of risks to that. I didn't touch on this one before, but if you are injured, you've got medical bills, you've got rent to pay, whatever the case might be. You don't know if down the line you're going to be out of work because of your injuries. Maybe you are immediately, and you think that it'll go away in a week. But if you accept that early settlement offer from the insurance company, you've released them from the claim. If you are out, lost wages down the line, they are not on the hook for that anymore. And so that is one of those longer timeline, concerns that you might have on a case. Is, are you going to be out of work? How long will you need to be out of work? If you need surgery down the line for whatever reason and you're out of work, how do you then get those missing funds back? Once you've already released them by accepting that offer from early on in the case. And so again, that's why I will always preach from the top of every hilltop I can find that even if it's a small claim, let an attorney do the talking for you so that you're at least having a set of eyes that is looking at it from your side, essentially, because their job is to their stakeholders, not to you.
And it's interesting you talked about, getting injured and possibly losing job. I had recently I was handling this case where a UPS driver, she was wearing long pants as she's supposed to, closed shoes, and she was approaching to a house with open garage. And so, drivers always have to look into directions and instructions where to deliver the package. So usually I get Amazon packages, I'm sure like you do every single day. But in this particular case, the purchaser specified, the garage door will be open. Please enter into the garage and leave it at the door inside the garage. And that's exactly what the UPS driver was going to do. And then all of a sudden, unexpectedly, this huge dog, so there was a dog bite injury, just jumped on her and bit her on the upper leg, causing her severe nerve damage. And she lost her job, and she lost a lot of her, everything that's involved in life. So it's just severe damage right there.
Yeah, dog bites are no laughing matter.
Can you give us an example of somebody, an injured person who decides to represent themselves versus hiring a personal injury attorney, and misconceptions related to that?
So I don't really, actually, no, I do. There was one former client at this point, that tried to represent himself on the claim and got me involved much later in the claim. And there was a very, very, very large gap in treatment. And from the client side, they're just living life. They're not looking at it as something that's going to be evaluated necessarily. But when it came time to negotiate the claim, that is something they will latch onto and like chew until it's overdone, but that is one of the biggest arguments that they try to present from the insurance side, saying, hey, we're not going to pay for this other treatment. It's, 3 months later from the first day of treatment. It's, 2 weeks after, you said you were better. There's any number of things they say for any sort of gap in treatment. The biggest thing is that when the case was brought to us, those are one of those things that if there was, communication on the case and, we discuss why things need to happen, that's one of those times where we educate them on, hey, if you have appointments, you need to go. If you are going to appointments continuously, You don't miss appointments. You go when you're scheduled. Make all of your concerns known at the doctor. That's something that strengthens your case because it shows that you are serious about your treatment. As far as misconceptions, I think the biggest misconception that I see from people that try to represent themselves in the process, um, is that they're going to save money. Ultimately, what ends up happening, and there's data to this. I don't have it on hand necessarily, but what ends up happening is that when you are represented, the amount that is paid out on your case, and not because the case is inflated, but because you have someone in your corner advocating on your behalf, they're typically something like 3 times higher than you would get yourself. And I only mention that to say there's a lot you don't know if you try to do it yourself. For example, the lost wages, that might be something they're not thinking they can pursue. That might be something that they overlook. Um, for some people, they don't think of all their medical care as related and able to be compensated on case. There's a lot of factors. For example, actually, that's a good one. Had a client just got off the phone with, and we're talking about the property damage side of his claim, and I had to explain that it's not just your vehicle that matters when it comes to that part. If you had a laptop sitting on the passenger side and someone rear ends you and that laptop goes flying and it explodes, they have to pay for a replacement. It's not just the vehicle. And so there's a lot of things that might slip through the cracks for someone that's trying to represent themselves.
Very interesting. Very, very good. Listen to Jeremy Pineres.
I care.
Yes. Now we're going to shift our focus to the landscape of insurance settlements. Can you, Jeremy, discuss trends and lowball offers from insurance companies pre-suit and explain how these offers can negatively impact injured parties?
Yeah. So this this goes a little bit, not trying to throw them in this thing, but a little bit close to the whole Luigi deny, delay, defend tactics. And this happens on almost every case at this point, where especially if someone's unrepresented, they will take as long as they can to make a liability determination, to get them set up for a rental, to start, paying the actual repairs on their vehicle. And a lot of that, in my experience, is because most people cannot take on the financial burden of not having a vehicle, of not being able to work, of, not knowing how they're going to pay rent, not knowing how they're going to pay the mortgage, whatever the case might be. And so when the insurance company is able to put that kind of financial pressure on somebody, they can then make that lowball offer. And it's a lot more attractive at that point. That is a lot of what I see. It's not necessarily a trend. It's been a thing for a while now. But as far as lowball offers pre-suit, I will say when they come through, we waste no time in filing that lawsuit.
Litigation experience of any attorney is very important. Can you share what it means for a firm to have a strong litigation experience and highlight how this experience changes negotiation dynamics with insurance companies?
Yeah, didn't realize that would lead right into this question. So it's very important because they have metrics on everything. I mean, literally, all of your prior claims, the body parts that were claimed, the treatment you might have gotten on the claim, and most importantly, the firm that handled it and the attorney that handled it. And so they know which firms are just settlement mills, pre-suit settlement mills. And so they will, work a case up, send a demand off, and whatever the demand is, they will make it work. Whatever the offer is, they will make it work. And by make it work, put somewhat of a little bit of undue pressure on the client, saying that, hey, litigation's gonna be expensive. You don't want to do this. Let's just take their offer. We'll make it work. Having a firm that has litigation experience, that has that drive and almost pettiness to their, representation, that if you're not treating my client fairly, I will just file suit. That is going to be my next response. I'm not sitting here trying to negotiate with you and shooting my client in the foot in the process. That changes the dynamics heavily because they know that if they don't negotiate fairly pre-suit, we're not willing to play in the mud with you. We'll just file suit. And so that ends up with clients getting better results on their cases. That ends up with clients feeling like they were seen on cases a lot more. So it helps to have litigation experience. It helps a lot, actually.
Absolutely. Thank you. Let's talk about some real cases and their outcomes. Could you provide examples of cases where firms that litigate achieve better outcomes and discuss the advantages of being prepared to go to trial?
Yeah. I mean, firms plural, I can't off the top of my mind speak to other firms, but there's been a number of cases where we'll send a demand off, and it's a straightforward auto collision case. Fault is accepted. Really the only thing we're discussing is my client's damages, and the response back is something that's below medical expenses. Really doesn't consider any sort of pain and suffering. We're looking at it going, okay, you're not actually trying to negotiate. You're just trying to delay this, And so we'll file suit in response. And a lot of times that gets the ball actually rolling to where they will either offer that policy limit to settle the case, or the attorney, once they're on it, says, hey, let's do minimal discovery just to at least explore the positions of both sides, explore the damages, and then we can start talking negotiation again. But I know that at that point, once the attorney's on it, we're negotiating in good faith, at least. I know, because at this point, at a certain point, you start knowing attorneys on the other side. I know that when I see that attorney on the other side, they're actually there to try and negotiate. They're actually there to try and make a fair offer to my client. And, on my end of things, I know that I can seek out the maximum dollar value for my client without ever having to see a courthouse or trial anyway. And if necessary, trial. But more than likely, once you have a firm that litigates and they've positioned themselves to be known on the other side that if you don't negotiate fairly, they'll just file suit and they will litigate it as if it is going to go to trial regardless, then that's where you start getting those better outcomes. You start getting the advantages of having put in the work on the front end to show them you mean business.
All right, Jeremy. So if anyone needs your legal help or has questions about whatever we talked today, how can they get in touch with you?
Yeah, so there's a few ways. The office line is probably the most direct. That's at 404-777-8777, and that is easy to remember for a reason. There is also the website, which is lawyerjp.com, like Jeremy Pineres. A lot of the times you can find me on Instagram as well if you just want to shoot me a DM. The handle for that one is JP Injury Law. And then if you ever need to email, email is jpineres@lawyerjp.com. And if there's anything more than that, I haven't thought of it, but yeah, you can also text that office line too. So
wonderful. I love it. Yeah, it's rare where you can text an office official line. So this makes everybody's
like
life so much easier.
We are accessible.
Yes, it's wonderful and so important nowadays. Again, this was so great. I hope our discussion about which I did already, so never mind. We'll cut that out. And then where the question was actually, let me repeat it. Yeah, I'll just repeat it. And this was so great. I hope our discussion about the hidden price tag, why skipping a personal injury lawyer can cost you a lot, was informative and educational. And as promised, here's a fun pop-up question for you, Jeremy. You ready?
Super ready.
Okay. If you could travel back to any era in history, which would you choose and what intrigues you about it?
Can I put a twist on that question because I suck at history?
Of course, go ahead.
Okay.
This is your answer, your question.
I would actually travel forward in time if I could, to maybe give it even 100 years, 200 years, just to see what the world looks like at that point. Not like necessarily geographical boundaries, which countries still exist and that kind of deal, but more so just to see where we're at technologically speaking. Because even in like the last 10 years, AI has become so involved in everyday life that you have people that literally will use AI to respond back to someone over text. And, there's obviously an environmental cost to all that. And hopefully we reduce that down in time. But there's an entire generation of kids even. And I hesitate to say kids because we're not talking about Gen Alpha at this point. I'm talking more like Gen Z. So maybe adults too, that use AI like we would have used Google back when it first came out. And so they're using AI to formulate meal plans, to create diet plans, to, like working out plans, I mean, to, create standard operating procedures. And so I'm curious to see where all that goes just on like a ground level here at Earth. But I'm curious to see where we get at with space travel and just like, exploring the stars and all that. Because, you have a more of a commercialization of it right now. But at some point, it's going to be accessible from an educational standpoint, hopefully. And I'm curious to see where we go as a society. Hopefully, it's not really hot still in 200 years. I hope we fix something of that. But I'm curious to see where we go. Yeah.
And you can
yeah.
maybe you can freeze yourself, using one of
Yeah.
these new technologies like we see in the
Beam me up,
movies.
Scotty.
And then make
Make
sure
me part of the
you sign.
experiment. I'm fine with that.
Make sure when somebody discovers your body 200 years later, because unfortunately it's not going to be your friend's wife, girlfriend, or parents.
Yeah.
It will have to be somebody that you don't know, but you sign the contract, and maybe I'll do the same.
Yeah. So, for example, like it was such a far concept before that you have your favorite pet and you want to clone them. You can you can actually do that now. I mean, like I wouldn't because there's only one special Caroline, but like there's so many things that we never thought possible that becomes possible in time. So I'm curious to see where we're at in a couple hundred years, even.
Wow, I love it. Nice. Yes. Oh, goodness. That again was Jeremy Pineres Law, based in the heart of Buckhead, Georgia, with Jeremy Pineres, the trial attorney here in Georgia. I want to thank you all for listening and watching our episode today. For more tips and tricks on legal funding and personal injury law and medicine related topics, follow me, download, like, and subscribe for It's Time for Moore Inkiry Funding podcast on several podcast platforms worldwide. And follow Moore Inkiry Funding on LinkedIn, Instagram, Facebook, Twitter, TikTok, Pinterest, YouTube, Google business profile, and my website at mooreinkiryfunding.com. I can't wait to see you, my dear listeners and viewers, of my next upcoming episode. Tune in for our next guest soon. Until then, be well. Thank you.
Thank you.